Good afternoon, gentlemen. Happy Sip Day.
Happy Sip
Have
Day.
fun. All right, I have a fun topic today, one that is near and dear to our hearts because it impacts a lot of people. And it's about naming beneficiaries, including when to name a trust, adding transfer on death to bank accounts or payable on death, what that means, and how that helps to avoid probate. So Tucker, I just wanted to kick it off to you to start talking about just the simple ones like POD and TOD, how that can affect probate processes in different states, and what that even is, naming beneficiaries.
Yeah, so I think it, like you said, it's extremely important. Um, Unfortunately, when you come up to those situations in life, those are probably some of the last things you really want to be worrying about, last things you want to be dealing with. So, beneficiary designations, TOD, POD, essentially what those all kind of mean. So, TOD, transfer on death, POD, payable on death, and then beneficiary designations. So accounts like trusts, joint accounts, IRAs, other retirement accounts, stuff like that. Essentially, what those designations mean and effectively accomplish is when the primary account holder passes away, what then happens to that account? Where does that go? So, like when you put a beneficiary on your IRA or your 401k, when you pass away, they automatically know, okay, this is going to my spouse, or okay, 50% is going to my spouse, 30% is going to my first son, 20% to my second, whatever it is. TOD, very similar type things where on the account, if you have a TOD account with you and your spouse, when you pass away, it'll automatically go to your spouse. Sometimes we see it too where grandparents, elderly couples will sometimes have TOD accounts, POD accounts with their daughters, sons, grandkids, things like that, so that when they do pass away, then it kind of takes the whole probate, like you mentioned, process away, makes it less complicated, and the accounts automatically know where they're going to go.
Right, and probate really just means the court is involved, right?
Hmm.
So the court is going to look at your situation, your if you have a last will and testament, they will likely look at the will to see how things are supposed to be designated, and then say yes, it's supposed to go to X family member or X charity or X individual. But if you name them directly on the accounts, you skip that process, and then the courts aren't involved, and you are able to get the money to where it was supposed to go and where you wanted it to go quicker. So, Joe, wanted to ask you just some of the importance of trust and how that can tie into all of this probate talk and how that can actually help avoid probate.
Yeah, I think probate often gets a bad name because it's a slow process. It costs a lot of money. The lawyers are involved, and it's during an emotionally charged event, right? But you will get it right. At the end of it, it's going to be court supervised. At the end of the process, you're going to get it right. So the TOD lane that you talked about before skips that, right? So think of it like the express lane. It's skipping all of that, but there's risks that you don't get it wrong or not coordinated with your wishes, depending on how relationships change over time. Trust are effectively taking all of that work on the back end that a court is going through to make sure it's right, and you're doing it on the front end. So people die, but trusts don't die. So in the language of a trust document, you might be specifying who gets what, when, and how, and then you're naming a successor trustee. So the day after somebody passes away, the successor trustee effectively can step in and start managing the property that's in the trust. So it's a lot more, it can be a lot more work and expense on the front end. But when someone comes in our office and they say, I want to make things as easy as possible for next generation of that, right? So think somebody, maybe kids have grown, they're out of the house, maybe grandkids involved, and then they kind of say that line of like, hey, I want to make things as easy as possible. Well, to make things as easy as possible, oftentimes you're going to go through the process of creating a revocable trust and retitling assets into the trust, which now, to your point, allows you to avoid probate and also kind of doing some of that work on the back end that would be needed to be done. You're doing it on the front end while you're able to make decisions and competent, and you're taking on that responsibility yourself rather than your county courthouse doing that.
Yeah, and it's really a really great thing when you are able to do that work on the back end because it makes life a lot easier for those who are, like Joe just said, already an emotionally charged event that have to then take care of the financial affairs, legal affairs of the person who just passed. And it just makes things smoother. It makes the communication clearer, and it takes pressure off of the survivors after someone passes away. So we really think
Yeah.
it's important. Sorry, go ahead, Joe.
Oh no, I'm sorry, Nav. That's right. One thing that jogged my memory when you said it is, what's the most common mistake you see? And I'm going to use myself as an example, but use this, Nav. Common mistake you see a parent with young children. What's the most common mistake you see them make as it relates to this conversation around beneficiaries?
Yeah, it's really naming them directly instead of naming the trust, which they've already did the work in to put the assets into to basically how they're supposed to be controlled before they're a minor, or sorry, before they're an adult, or if you want to restrict access to some of the money until certain ages where you know, hey, at 21, you might not want them to have access to tens of hundreds of thousands of dollars, but maybe at 35 you do. But and you did all that work, but then instead of naming the trust as the beneficiary, you named the kids outright, and then it bypasses all of those things that you did. So that's why naming the beneficiary is extremely important when you actually have trust that you already did all the work on.
Yeah, sorry I leaned away, but I was looking for my binder. It's like you'll see people with these big binders like, well, I did all my estate planning work, and it looks like this isn't my actual binder, but it looks like that. I did all those trusts and I paid a lawyer a bunch of money, and then they do what you said. It's like, oh, on my work forms, I put my 5-year-old daughter in as the beneficiary. It's like, well, that supersedes everything you did in this, fancy binder that you got from the attorney when you did that. So that coordination between the beneficiaries is key. I would say, especially. I mean, it's everybody, but most commonly I see that mistake. It's a parent with young children who goes through the work of creating trust for the children, but then names the children outright as beneficiaries. And to Tucker's point earlier, when you had the split of the 20 and 30%, I see it often where somebody has beneficiary 2 kids, and then they end up having 3 or 4 kids. Like they didn't intend to not name the third and fourth, but when you're naming them individually, it's like you got to stay on top of that. If you're actively having more children or adopting more children or growing your family, when you're naming them outright, that creates that risk. Whereas in your documents, it's going to say Nav's 2 children plus any other children he has in the future, in that document to include a potential growing family.
Yeah, that makes for a
Absolutely.
really awkward family dinner.
Yeah,
Yes, it
well,
does.
awkward, but also after you're gone, you can't fix it. All
Right.
this stuff comes in after you're deceased, and it's like you might have named 2 people, and maybe you had three. Or if you're naming grandkids, maybe you name 4 grandkids, you end up with 8. Like all of these problems end up coming up in growing families.
Right.
And that is why we always encourage looking at estate documents regularly. So it's not just a one-time do it, set it, and forget it. You want to make sure that you're the people you name, not only the beneficiaries, but who are to help with the administration, the trustees, personal representatives, that those relationships haven't changed, and that's exactly who you still want on those documents. So we could talk about estate planning all day long, but I think this was a really good use of time, and hopefully anyone who watches this will get to learn a little bit more about the process. And if you have any questions, feel free to reach out. Thanks,
Cool.
guys.
That's that.
Thank you guys.